So now we're going to move to legal considerations. Now, as I said in the facts, that Ivana and Donald want to start a business together. And so the first legal consideration that we're going to talk about is, should Ivana and Donald draft a partnership agreement? Now, the first bullet point, friends today, enemies tomorrow. I cannot tell you how many situations that my firm runs into where after the fact, we represent one side of a failed business, failed business arrangement. So the business hasn't even failed yet, but just a failed business arrangement. So, when you start a business, everyone's happy. No one's making money yet. Usually, everyone's happy. Everyone kind of has assigned tasks, etc. But then, as time moves on, you quickly realize that it becomes very difficult. Lots of things are difficult to do with other people. Like traveling is very difficult to do with other people. Living with someone else is very difficult to do as a roommate or in a relationship. Those are difficult things to do. Well, this is added to that list of starting a business with a partner is a very, very difficult thing to do. And so the question of whether you should draft a partnership agreement, the answer, it's just absolutely yes, because despite the fact that, Ivana thinks that Donald is the one, and in this particular story, they go on to get married and make lots of money, and then Ivana takes him for a lot of money in this particular story. But, that's just the fact is what happens is that people have disagreements. So, a partnership agreement, it's just a contract. It's a contract between it's a contract between your partner, and it's a contract between the legal entity that you actually set up. Now, in terms of the types of agreements, we're going to talk a little bit about the different types of business entities, but if you set up a limited liability company, the agreement that we're talking about here in terms of a partnership agreement is called an operating agreement, and that's the agreement that's going to outline exactly how the two partners or partner or more partners operate together and how the partners operate with the actual firm. And in an LLC, the limited liability company, the partners are called members. The other type of agreement, if it's a corporation, it's a shareholder agreement. They just have different names, but they have really the same standard clauses in them. But really the purpose of them is as I described. So in terms of what goes into these agreements, like the standard clauses, and the standard clauses are really kind of what people would fight about. Like what do we see that people fight about? One of the things that people fight about is how profits are distributed. At the beginning, when there's no money, everyone kind of generally thinks, well, or you don't talk about it, or no one says anything, and you kind of say, well, there are two of us, so it's going to be 50-50, right? But then someone always has in their mind that they're doing more, right? Whether they are or not, it's irrelevant, but they have it in their mind that they're doing more, or they've contributed more. But that's one of the things that you would want to put in the agreement. Another important thing that you want in the agreement is how decisions are handled. The benefit of sitting back and kind of contemplating or thinking about everything that could go wrong is that you actually try to address how you're going to handle those things that could go wrong before they actually do go wrong. So, very common provisions in these agreements are how do you handle deadlock. If there are two partners that each own 50% of the shares and you don't agree, kind of what happens? Like, does it go to arbitration? Does one person get, get to decide? Even what types of things are going to be kind of subject to this deadlock provision? Is one person going to manage the day-to-day operations? Those types of things. So all of those things, and really as much as you can think of, should go into these agreements. Who contributed what, and how much it's worth, because we talked in the facts that Donald and Ivana had both developed code that they both now hold in two separate entities. And now they want to start a new business entity, and they're going to move that intellectual property, because it value, right? They're developing a mobile application. The thing could be ready to launch or almost ready to launch, and that has value. And when you say who contributed what, Ivana has $100,000 in cash, Donald has $1,000 in cash. Maybe that all goes into the business, and that's one thing that's easy to kind of say, well, someone it contributed 1,000, someone contributed 100,000. But then, intellectual property or other equipment, all of those types of things you want to be able to kind of memorialize so that if there is a liquidation or if the company doesn't work out, that you're not kind of debating who gets what. I'm doing a settlement agreement for these two for this one company right now, and they were two partners, and everything was fine at the beginning, but they didn't write down anything, not anything at all, and even as I represented one side, I actually had to take the argument that they hadn't formed anything, because it was really a situation where my client contributed 95% of the assets, the other client contributed 5% of the assets, but then when they filed their tax form, the tax form said it was 50-50. So the other side was making the argument that I own 50% of the company, but that was the only legal or other document that existed. But I kind of had to go back and make the argument that no, because they didn't do anything. Not only did they not do a shareholder agreement, they didn't have a shareholder meeting, they didn't kind of issue stock. So I kind of had to make the argument that this company hadn't even been formed yet. So so we're dealing with this division of property for a legal entity that has not even been formed yet. But to the extent that they had all those things written down, it would have been very easy. Like, my client has all the power in this case, but the other person would have had a lot more power if he was able to kind of define in an agreement what he contributed. So another legal consideration, what type of legal entity should Donald and Ivana set up? So we know that Donald set up a sole proprietorship, and we're going to talk about two other types of legal entities, corporations and LLCs. The only legal entity that we should just completely cross off the list is a sole proprietorship. So we should, if you're setting up a business, if you're an entrepreneur, there's really no reason to set up a sole proprietorship. It could be that you feel the benefit of a sole proprietorship is it's the simplest to set up. But I think that you'll see as we talk about limited liability that the risk associated with that far outweighs the ease of setup. So the other two types of entities, legal entities to set up, are corporations or limited liability companies. And really the key aspect of both of these types of entities is that your liability is limited. So some say, well, no one's going to sue me for anything, and what do I have? Or I run a pretty streamlined operation here, but you can be sued for anything. Someone can come into your premises, they can slip and fall, and they sue you. If you don't have a limited liability entity, then they sue you, like you personally they sue, and they can get a judgment against you, and the judgment doesn't go away, right? So even when you are making money down the road, you would have to pay them. Then other things that you may not think of, even something like copyright infringement, like something like taking, you develop a website and you use pictures and you think photos and you think, oh wow, that's fine, but then all of a sudden someone is very angry and they're sending you not only cease and desist letters, but they're sending you into the copyright law sometimes allows for just statutory damages, like you infringe and you just get, even though the other party hasn't actually suffered damages, then you could be subject to actual damages. So there are lots of reasons that you can get sued, and the biggest reason you set up a limited liability entity is so that it's only the entity that can be sued and you are not subject to any personal liability. So now kind of the decision of which one of those two to select, a corporation or a limited liability company. Now, one of the, when clients come to us and they say, which one should I do? And we say, well, here's a questionnaire, but really, the key aspects of what dictates which entity you're going to set up are some of the things that we're going to talk about. So, do you plan on raising capital? So do you plan on, is your business one that you plan on going out and seeking and attracting capital from investors? And if the answer to that is yes, then there's a very good chance that you're going to set up a corporation. And the reason for that is that you are going to, when you are seeking capital from investors, you are issuing a product, and everyone knows what a common stock is, everyone knows what a preferred stock is, but many people, if I say, well, what's a membership unit, and they say, I have no idea, because in an LLC that's what the product is. It's a membership unit. That's what you have to call it. It's called a membership unit. And then you have to develop, so while most people kind of know what a preferred share is, when you start to say preferred membership unit and you start to develop these things that people really aren't familiar with the concepts, I think it just becomes a lot more difficult. difficult. So really, with raising capital, the corporation gives you a lot more flexibility. Similarly, if your business gets large enough and your raising capital moves from just raising capital from friends and family and other investors to venture capital funds, a venture capital fund would never deal with an LLC. They would immediately get you to switch the LLC over to a corporation, which isn't the end of the world, but it's just more legal work and more headache. But they would get you to switch the LLC over to a corporation, because that's what they're used to dealing with, and that's what, when they are trying to raise capital, or when they're defining the terms of the product that they're buying from you when they give you money, they're not interested in dealing with membership units or any other terminology other than that. Now, the other consideration when you look at which type of entity to set up has to do with how sophisticated you are. So the whole reason that LLCs were created was because people thought corporations were too complex. So LLC is a relatively new invention. Now the reason people thought corporations are too complex goes back to, similar to the argument that I was making with that case that I'm dealing with. When you have a corporation, what you're required to do is file documents with the State Department, so the State Department sets up your corporation, so you have a name of a corporation. But then what you're required to do is you're required to, even if it's just a corporation that you formed yourself, you're required to sit down, have a meeting with yourself. You have to take minutes of that meeting. You have to, memorialize everything, and you have to issue stock from the company to yourself or to the other investors. And all of that has to be memorialized in minutes. And what we call corporate formalities have to be adhered to. And if they're not adhered to, you can it's almost as if the conclusion can be that it's almost as if you didn't have a corporation, that you really could be personally liable. It's called piercing the corporate veil, but but that's in essence. So people found that confusing. I personally don't find it that difficult, but people did find it confusing. So they created an LLC, and all of those corporate formalities are eliminated with an LLC. So with an LLC, all you have to do is prepare an operating agreement, generally speaking. And the operating agreement, if it's a single member LLC, you could probably download something from the internet that would be sufficient. If you had two people, then you might want to hire someone to draft a proper partnership agreement. But in essence, the LLC is just a lot simpler. You don't have to adhere to those same corporate formalities that are associated with the corporation. So some people opt for an LLC because they just find it a little easier. So some people, for example, they don't plan on raising capital. They're starting their own business. They want to kind of have the least amount of complexity, and they opt for an LLC. The other reason that that people pick one or two, either a corporation or an LLC, has to do with tax returns, and this is kind of a more practical implication. And really, with a corporation, you have to file it's a separate legal entity, and you have to file a separate tax return. So you have to, most people can't file a corporate tax return. So you have to hire an accountant, and you have to pay the accountant, and it's not cheap, and you have to do that in perpetuity, every year, and sometimes there are going to be quarterly filings. So with the LLC, it's a little different, because an LLC is, and we're going to talk about S-election, but an LLC is what's known as a pass-through entity, and you don't have to prepare a separate tax return for an LLC, and instead you just get to add one schedule to your personal return. Because the way that an LLC works, you're electing this, but the default election is just that the LLC is set up, and it's as if, really for tax purposes, that you are the LLC. So if an LLC makes $100,000 in profit, that $100,000 gets put on your personal tax return, and it's one schedule that is on your personal tax return, rather than actually having to prepare a completely separate return. So it's something that when you start to add up the cost, you'll find that a corporation is probably more expensive, because the paying for the tax preparation services of a corporation can be quite costly. Now, Ivana had asked, she set up a corporation, and someone mentioned to her something about an S-election. And what an S-election is that one of the reasons that sometimes people opt for an LLC as well is that, as I said, it's a pass-through entity. Now, what a pass-through entity does is it avoids double taxation. So the way that entities are taxed in the United States. If you set up a corporation, then you're going to, if, let's say you make $100,000, a corporation makes $100,000, then there's a corporate tax that's applied to that, right? So it's a percentage of the profits that's applied. So now what is left you can distribute to shareholders, and then shareholders pay another tax. So that's called double taxation. So what S election allows you to do, as long as everybody in the corporation, like let's say there are 2 of you, as long as everyone decides that they want to elect for S status, as long as everyone decides it, because S election is a IRS designation, then the corporation is treated as a pass-through entity. So still a separate tax return is prepared, but the you avoid double taxation. So that's but S election can get fairly complicated, but just something to maybe keep in mind. 83B election. So to the extent that you are receiving shares, like so if you're a founder or you're kind of investing in another company and you're a founder and someone's drafting an agreement for you and you're getting shares of a company, speak to your tax accountant, because the 83B election is a very important election that you have to make. And I'm just going to touch, it is a somewhat complicated election, but in essence what happens is that if you have certain types of shares, then you could end up paying taxes on those shares even though you haven't received a penny, right? So the 83B election kind of avoids that taxation occurring, on an individual level. So just something to keep in mind. Whenever you get shares, whenever you start a company, whenever you get shares, speak to your accountant and say, what is an 83B election? And they can go into it in more detail. One question that we always get from clients when they come in and they're setting up a business entity is whether, we're in New York, and should we set up the corporation in New York or should we set it up in Delaware? Now, there's no kind of clear-cut answer. The reason that Delaware, and there are also some other states that are very friendly, New York I'd say is not that friendly to corporations, but they're friendly in terms of are there filing requirements? Do they just kind of leave people that set up corporations alone? Do they have a lot of regulation? So if they have a lot of that, they're unfriendly. Delaware doesn't have much of that at all. And then there's some other states that are very friendly as well. So sometimes people kind of ask, well, should I set up my corporation or my limited liability company in another state? Generally speaking, the answer is that you should set up a business entity in the state that you're doing business in, right? That's kind of generally speaking, because the fact is you're going to have to do that anyway. So if you set up a corporation in Delaware, for example, and you were doing business in New York, and doing business is a legal term, so it's a defined term. So if you'd have to look at a number of things like, do you have an office here, et cetera. But let's say that the government defined, said that you are doing business in New York, then you would have to adhere to New York filings anyway. So you would actually impose 2 sets of filing requirements on yourself, and the benefits associated with Delaware probably are, especially at a small company level, are probably not that significant. And so generally we advise people to kind of set up in where they actually plan on doing business. But that's a very, very common question that we get. So the next thing that we're going to talk about is intellectual property. So we know that Ivana and Donald have both spent a lot of time coding and doing different things like that. And we talked a little bit about this already, but kind of who owns what and kind of tracking who actually owns that. We represent a company right now where there's a Polish company and an American company, and both kind of founders, or 2 founders in Poland and 1 founder in the American company. They each individually have intellectual property. We set up a new company for them, and we're transferring the intellectual property into that new company, and they have a significant business venture that that's going to be associated with that. And they've already attracted venture capital funding. But but one of the things we had to do from the beginning was kind of go through and make sure it was crystal clear what was being transferred into the company, what it was valued at, et cetera, so that there were no issues with that later. Another thing with independent contracts, especially if your startup is a tech startup, is that if you hire independent contractors to develop code for you, you want to make sure that you have a good independent contractor agreement, because one of the things that are in that particular agreement is that you own the code, right? Because you don't want to be in this situation where, whenever, no one cares about what you've done if it's not successful, but the second it becomes successful, then everybody wants a piece and says that they did it, they made it, it was their idea, it was, all of these different things. But, so, you want that agreement to be crystal clear that they're doing work for you, they're doing it on a contract for hire basis, and that they are, the code immediately, all intellectual property rights actually immediately vest with you. So it's definitely a very important contract that you definitely want to get them to sign. We talked about IP being transferred. And just, another thing just to consider, in this situation, especially when you have Donald and Ivana who had separate entities before they, started working together. We have another client who was a very similar idea, and we had to bring in tax counsel before to kind of advise on exactly how the IP should be transferred, because there, with everything that you do with setting up a company and, running a business, kind of getting investors, always in the back of your mind, you should have tax tax consequences. Because even more so, if I had to decide between hiring me and hiring a tax attorney, I'd hire a tax attorney, because the tax attorney is going to save you money, right? Like I'm going to, you comply with regulation or whatever, but the tax attorney is actually going to structure things so that a year or 2 years down the road, you're not paying way more taxes than you had to pay if you just did some basic tax planning. So it's just something to consider. Tax counsel, very important, and we regularly, whenever we enter into a transaction or kind of work on deals, we always work on them in conjunction with tax counsel. And then just some of the things that you consider in terms of intellectual property, trademark, patents, copyrights. And when you start up a company, a lot of the time you don't have a lot of money, right? So one of the things to always consider, if you have a good idea, there are a lot of resources out there, right? So, there are incubators that, if they like your idea, they'll take you on and they'll offer kind of free legal advice to you. There are firms, there are big reputable firms out there that they'll do what's called a provisional patent for you and not charge you anything until your thing starts making money. So they kind of do it as a loss leader type thing, because they are. So, never be afraid to kind of seek out legal counsel, because it is, everyone recognizes you're on a budget, so it may not be that you can do, you may not be able to come to my firm, for example, but everyone realizes, or there are lots of opportunities for people to assist entrepreneurs and startups, and so you just have to kind of seek out those opportunities. We actually, in some cases, we had one client who came to us. They did their investor visas. They, raised capital. I think they raised around $800,000, and then they were accepted into an incubator in New York. So, they utilized that incubator after that to get some kind of legal services and things like that. So. Okay, so now we're going to spend this is really the last topic, but it is. We're going to talk about raising capital in the United States. So just some basic concepts, right? So when you sell securities, right? So when you start a company, if you start a company with a founder, and you both, let's say it's a corporation, and you say you issue 1 million shares, and one has 500,000, the other has 500,000. You don't have to do anything in terms of the SEC at that point, right? If you're both actively involved in the company. But let's say you want to raise money, like that example that I just gave you, where the people raised around $800,000 from friends and family, and they issued preferred stock. Now, you can't give away, you can't sell, you can't issue securities. It's all the same, whether it's a gift, selling. You can't issue securities in the United States unless the securities are registered. Registered means when you see these large companies and they have financial statements and they're audited and they have private placement memos, etc. So you can't do that in the United States unless they're registered, with the exception of if you can find an exemption, right? So one of the things that we help clients do is that when they're ready to kind of raise capital, we kind of explain the law in the area to them, and then we kind of tell them, okay, that if you're going to attract investors, here are the exemptions that are available to you. And because no one wants to, like a small company doesn't want to register securities, right? You might spend $100,000 in legal fees kind of registering securities because it's quite a process, right? But so you want to find an exemption. Spend time going through these are the exemptions, and that means that you may only be able to sell to these types of investors. The example that I just gave you where the company raised $800,000, they had another $50,000 of investors in 4 states within the United States, but those investors weren't what are called accredited investors, so they weren't sophisticated investors. And so we actually advised them not to take the money from them, because if they took the money from them, they wouldn't be able to utilize the exemption that they actually utilized. So they ended up foregoing that $40,000, $50,000 because the rules are very, 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 very strict. Now, a lot of the time when people, do a startup and they, kind of do whatever they want, right? We have a company that we're representing right now that very, great startup, and they have a, kind of sales and a very, very large, kind of a household name institution for their product. And but they did 2 offerings where they didn't use counsel and didn't follow any of the rules. So now what's happening is we're trying to fix some of that, but also what I advise them is what you're going to have trouble with now is when a venture capital fund comes along, because the way that it works is you do, a lot of the time people do friends and family round financing. They get some money so they can further develop their product and their business idea, and once that's done, then big companies, these venture capital funds, see the potential in these companies, and they say, we're going to give you 5 or 10 million, or how much, give you money, and we're going to take back a portion of the company. So, but the venture capital funds often, if you have, if your company is too much trouble to deal with because you have, either flagrantly ignored SEC law or have a lot of issues with that, then, it could be that the venture capital fund decides that they, don't want to invest in your company because they have lots of options, right? They have lots of options. Great. Okay. Well, there's a little bit about myself there, and I think we talked about most of the things at the beginning of the presentation, and then we will move to questions and answers.
Okay. Thank you.
Okay, my pleasure.